for these Equal Pay Act claims, every paycheck where there's a discrepancy starts your statute of limitations period running. Because what you're saying is also, it's good business sense in addition from a legal perspective for risk management, because these are the types of claims that if you don't engage in the maintenance that you just described and looking to the quiet employee, if you get audited and an employee brings a claim, it's 6-year look back.
Ooh.
So it's a 2-year statute of limitations under the law against discrimination.
Okay.
But for these Equal Pay Act claims, every paycheck where there's a discrepancy starts your statute of limitations period running. Okay. So every time that there's a discrepancy, you go anew, which basically is every 2 weeks. You can then go back 6 years to look, right?
Wow.
So you can go back 6 years. There can be all kinds of liquidated damages, and there's attorney's fees and costs awarded to the counsel who brings the claim. Now, even if it's a low-level employee who's making minimum wage, this is a claim that is very desirable for plaintiff's attorneys, because if, as you said, smoke fire, it's usually there. And it doesn't matter if you're recovering for the employee $5,000 or $50,000. You're going to have to pay those attorney's fees and costs. So that's where you end up then paying the attorney fee of $600, $700, $800 an hour, it could even be, to prosecute that claim. And that's where sometimes the bigger expense can be. So when you're looking as a small business and where to put funds, maintenance, maintain the wheel.
And that is so true. I'm so glad you said that. So I hope everyone is listening. Oh, HR is an expense and having an attorney is an expense. Not when you're utilizing this the correct way, AKA maintenance. You save thousands of dollars, to say the very least, on having an HR person on deck, having an attorney on deck, because it's key. We work hand in hand, HR with your attorney